All right. Good morning, everyone. Welcome to the House Committee on Government Operations and Military Affairs. It is Friday, January 12th, and I am happy to have a nice full room here this morning. We are going to start hearing testimony this morning on H 612, which is an act relating to miscellaneous cannabis amendments. And I'm pleased to have Michelle Childs here with us once again. So welcome, Michelle. Thanks for being here.
Thanks very much. So for the record, Michelle Childs, council, and taking a look at as introduced. So I'm just going to do a quick walkthrough because then we've got a lot of witnesses this morning, and I know I'm being followed up by Chair Pepper. So this bill is kind of the annual housekeeping and bill from the agency. And so I know that he can give you a lot of context for why these particular provisions are in here. So starting on page 2 on section 1, this is an amendment actually not in Title 7 where you have the cannabis laws, but in Title 6 for agriculture in the chapter pertaining to hemp. And so this is an amendment to the definition of hemp products or hemp infused products. And James can give you the background about it. But you remember a couple of years ago, you gave the CCB the authority to regulate hemp-derived and synthetic derived THC products. And I think he can kind of fill you in a little bit on the background of there's a lot of products out there that are coming oftentimes from out of state manufacturers that are being sold in a number of places, whether it's like a smoke shop or a convenience store, things like that have high THC content but are hemp derived. And so we've been having discussions, and I think when you have later committee hearings on this, if you can kind of organize around like maybe an hour for us to really dig deep into the hemp stuff, and I'll ask Michael Brady to come in too, since he's so familiar with the hemp laws, because we're kind of divided up. We always have been back when cannabis was illegal and hemp was legal. So there's 2 of us working on this particular issue. So this definition change in subdivision 4, you'll see the language that starts on subdivision B on line 11 is an exemption, is that hemp derived infused products and hemp products do not include any substance that's prohibited or deemed a regulated cannabis product according to a rule by the CCB, or that contains more than 0.3% total THC on a dry weight basis. So the 0.3% is the distinction between hemp and cannabis in terms of the law. And I think we can talk to you a little more about the types of products and what they're seeing and what we're trying to get at here. So next page, on page 3, section 2, this is in the definition section for, you're in Title 7, you're in the cannabis establishments chapter, and this is a definition for controls or is controlled by. And this pertains to who has to basically disclose to the CCB, who has an interest in the business for purposes of doing a background check and their information being a part of the application. You might recall over the last few years, really since, the CCB has been rolling. So one of the requirements is that there's background checks on these folks, and one of not only just a state check, but an NCIC check that's done through the FBI. And Vermont, as well as most other states who have a regulated market, have been having a difficulty meeting the standard that the FBI has in terms of how we define who needs to have the FBI check. And so this is yet another attempt to try to meet that. The FBI has not said it needs to say this. It just says that doesn't do it. And so it's a little bit of a moving target. And again, I think Chair Pepper can kind of fill you in on the attempts there. And this had, my understanding is that this has been recently adopted in a couple other states. So section 3 is amending the definition, amending the section on prohibited products. You might recall that in 2020, when the adult use cannabis program was established, this section was added there, saying that there are certain types of products that cannot be manufactured or sold in the adult use regulated market. So this section does not apply to the medical program. So you'll remember that if you are a registered medical patient and you're getting your products from a dispensary, you can have higher THC products and certain products that are not available through a retailer that is just selling to the adult use market. So you'll see in section 3, in subsection A, the first restriction there that's on line 16 that's struck is right now that there is a cap on the amount of THC for flower, and that's a 30% cap currently, and that's being struck on line 16. And then on page 4, you'll see all of subsection B is struck. And right now that is a prohibition on solid and liquid cannabis concentrates with a greater than 60% THC. And so that is also being eliminated. So those products, if you adopted this particular amendment, means that they would no longer be restricted in the adult use market. So section 4, this is moving into the medical program. So just a little reminder that in order to be a patient on the medical cannabis registry, you have to have a qualifying medical condition. Then you have to have your medical provider who you have an established relationship with fills out a form attesting to the fact that you have a certain medical condition. Remember, they don't prescribe cannabis. They just are filling out a medical verification form that is then submitted to the CCB as part of the patient's application. And then that would entitle them to be on the registry. And when you're on the registry, you can have larger amount of cannabis. You can also get products from a dispensary that wouldn't otherwise be available through the retail market. And so you see the current list of qualifying conditions, and you'll see on line 17 and 18, there's a new condition that's added there, which is ulcerative colitis. Next page is page 5 and section 5. So this is on registration fees. So patients and caregivers have to renew their status on the registry. This probably looks a little familiar to you because this same proposal was in the CCB's housekeeping bill last year. It used to be an annual renewal, and the CCB wanted to go to it being for certain intractable conditions that do not include, that's not chronic pain, because there are a substantial number of people who are on the registry for chronic pain. Chronic pain would still have to do an annual, but all other ones could be for 5 years, and that was proposed last year. And then my recollection was that I can't remember if you guys accepted the 5 years here, but I think it got knocked down to 3 in Senate Health and Welfare, but along the way. And the CCB would like it to extend it to 5.
I think there was also a desire to look at registration fees kind of holistically this year, not last year, from several committees that have the fee jurisdiction. So.
All right, well, that tees me up for section 6, which is dropping the fees for the dispensaries. So back, we've had dispensaries. I think the dispensary legislation was done in like 2011. We've had a medical program. I think that was created in 2004. So we've had it for a considerable amount of time. And those dispensary fees were set pretty high initially. And you remember, when there was just a small number of shops and they were only medical. And so now that there's a retail market, and then also I'm sure Chair Pepper will talk to you about the concern that Vermont may lose its medical dispensaries kind of being eclipsed by the retail market. And I think you also have in legislation that you've passed in 2020, a General Assembly's intent is to try to keep the medical program and the medical dispensaries going to serve that particular market. And so this is dropping the fee for the application fee from $2,500 to $1,000. And then it would be an annual fee. Currently, right now, the annual fee is $25,000 and it will be dropping it to $5,000. So just as a comparison, a retailer is a $10,000 annual fee.
We'll hear from the Cannabis Control Board about realize those are some big number changes. We'll get the why. Michelle's doing the what. We'll get the why from.
Yeah. So on page 6, section 7, so this is, you'll recall that there's a requirement that prior to any licensed cannabis establishment putting out an advertisement, that advertisement has to be reviewed by the board to make sure it's in compliance with statute and rules regarding cannabis advertising. And there's a provision in there for CCB collecting and charging fees. And my understanding is that they don't do that. And so they ask that be repealed. Section 8 is just a technical change. You'll see there on lines 14 and 15, it's just a relic there from when we only had the medical program. And when there was only a medical program, it was regulated by the Department of Public Safety. We didn't have a cannabis control board at that time. And so that's just getting rid of that and substituting cannabis control. Section 9 is in Title 20, so public safety. And this is in the chapter having to do with fire safety requirements. And so there are fire safety requirements for public buildings. There's a lot in the law that talks about what is a public building, what is not a public building. Things that are excluded from the definition of public building include a lot of farm type buildings. And so this is adding on to the long definition, actually a farm building. So a farm building that it's used in outdoor cultivation for cannabis by someone who's licensed. And so again, I think James can talk to you about why they feel it is appropriate to exempt those certain types of farm buildings that are used for cannabis cultivation from some of these fire safety requirements. On page 7, on section 10, this is a recommendation from the CCB that when a medical patient purchases cannabis or cannabis products from a retailer, so from an adult use retailer, not a dispensary, that the retailer would pay the tax on those products instead of the patient. So under current law, medical patients who are purchasing from a dispensary don't pay taxes. So if you're a patient or a caregiver, a registered caregiver for a patient, there's no tax on those products. But you think about the number, I don't know how many, I think 60 something retail shops are operating in the state, but we only have 5 medical dispensaries. So it may be much more convenient for a patient or their caregiver to be able to purchase products at one of the retail stores instead of the dispensary. And so this would allow a mechanism where they wouldn't wind up paying more perhaps for the same products at a retailer than if they were able to get them at a dispensary.
Very interested to hear about the mechanics of that. Representative Chase.
Is there any parallel to that in like other medications? Like if somebody purchases something from a pharmacy versus a grocery store, is there any difference in sales tax?
I don't know, you would have to talk to we'd have to check with the tax people. I don't know generally how that is. I think this isn't necessarily changing the tax. The tax would still be paid. It would just be paid by a different person.
Thank you.
Mm-hmm.
Yeah, I think in here, just from a jurisdictional perspective, we'll want to think about how this affects the retail market and how it fits in. And then we can flag some of the issues in terms of the mechanics of how it's collected, whether that's an appropriate tax policy for our colleagues in Disney. But this is definitely one of those gray areas where the way you collect the tax has an impact on the policy and the way that the market functions. So we'll give it our college try of reviewing it in here, and then we'll send it upstairs if this committee decides it's the right policy.
And that proposal, that there was something to that effect in the CCB's proposed administrative rules earlier last year. And then once that came through LCAR, it seemed as though they really needed kind of some specific intent legislation from you in order to proceed with that policy. So they're back here asking you for permission, but they were before LCAR and the issue.
Okay. Representative Higley may be ahead of most of us on that then. Okay. Anything else we should know, Michelle?
Nope, I'm gonna sit right there. So I've got a little more time, so I'll still be around if you have any more questions.
Thank you very much. Chair Pepper. Please join us. Welcome back to GovOps.
Hey, thank you. It's really hit the ground running.
We're trying to start everything. I don't know. Next week and the following week will be pretty full for us.
Well, thank you for having me. My name is James Pepper. I'm the chair of the Vermont Cannabis Control Board. I don't know where you'd like me to start. I do have some slides that kind of give a snapshot of the market, kind of tell you how well or not well we're living up to some of the expectations that were in the kind of enabling statutes and then the subsequent legislation. I can do that, or I'm happy to just jump right into the substance of the bill.
No, I think, how much time do you think it would be? It's just a few slides, right?
It's just a few. They are posted to your website.
Yeah,
And so I
pull
will,
that up. It's posted under James Pepper's name. And yeah, I think that would be great to remind us of the context. Will help folks understand your rationale for some of the policy.
sure. Yeah. And so again, I think we met with some of the lead sponsors of the legislation when we were first seated to establish what the expectation was for this market, what people wanted it to look like. And I think some of the policy goals that were articulated were we should focus on small local farmers. We should try to shift the legacy operators, the kind of current illicit market, into the regulated market as opposed to kind of stamp them out, which is what a lot of other states attempt to do with larger corporate entities. We were asked to support individuals that have either been personally impacted by cannabis prohibition or come from communities that have been disproportionately impacted by cannabis prohibition historically. And then, of course, we were asked to generate sufficient revenue to cover our expenses and then also to make strategic investments in substance misuse prevention, education, and after-school programs. So looking at kind of how things have shaped up, we began issuing licenses in May of last year. Our first retail operation opened in October of 2022. Thank you. So this is kind of the snapshot as of today. We've issued a total of 560 licenses. We have 85 that are pending approval. The vast majority of them are for cultivation, and 80% of our cultivators are tier 1 small cultivators, meaning they're growing on 1,000 square feet. So I think we've been somewhat successful. There's always room for improvement, but somewhat successful in this attempt to focus on small local cultivation and to bring in the kind of current legacy market into a regulated space. Other kind of notable pieces on slide 2, we have 73 retail operations around the state. We have 11 more pending. We have 2 testing labs. We have a decent number of product manufacturers, 75 total, 11 in the queue. And yeah, we're, I think, starting to see this market mature in a positive direction. On slide 3, we look at the kind of distribution of what are the so-called social equity applicants. These are, as I mentioned, people that have either been arrested and incarcerated for cannabis-related offenses, or they come from communities that have been disproportionately targeted for cannabis-related offenses. We have, I think, 85 of our licensees fall into that category. We know that not, cannabis prohibition was kind of one tool in the toolbox of kind of disenfranchisement, and that there's any number of government-led or government-sponsored activities that have disenfranchised other demographic groups, that aren't directly related to cannabis. So we created a second tier of applicants called economic empowerment. These are businesses that are women-owned, veteran-owned, LGBTQ plus owned businesses, and they get some priorities. They don't get the full kind of spectrum of benefits that a social equity applicant gets, but they get some expedited review and some additional technical assistance from the board. So we have 118 of those. And then an important metric for us always, something we always keep our eye on is in an uncapped licensing system, how much canopy, how much growing capacity we have licensed in the state. So on slide 4, you can see how much canopy we have issued. And again, this is a closed loop system. If there's a dramatic oversupply of cannabis in a given year, there's no legal outlet to kind of sell it to another state or, it just leads to kind of a fluctuation in the price of cannabis. On the flip side, we don't want a dramatic undersupply, which would, send prices upward and, kind of push people back towards the unregulated market. So trying to walk this balance is important. And then one thing that we also like to kind of keep an eye on is not just how much are we licensed, but how much are our cultivators actually utilizing. If you're licensed to get 1,000 square feet of canopy, but you only want to grow 30 plants, then we're missing kind of an important calculation in our projections.
Could you just clarify, because one place when I first saw this slide, I could see people reading it as the cultivator using the canopy that they've been licensed versus the product that's produced under that license being utilized. I'm taking it from what you just said.
Oh,
it's how much are the folks who are licensed actually growing?
Yeah.
How much is growing being?
That's right. Yep. And then, yes, just clarify, yes, we're going in when we're doing site visits and calculating how much of this grow room that you are authorized to use 100% of are you actually using. So it helps kind of fine tune how much product we're supplying for the entire market. And then, of course, an important factor is whether you're growing indoors versus outdoors. I mean, a typical grower could easily harvest 4 times a year indoors versus once a year outdoors. So there's a kind of, we use a 4-to-1 ratio to determine kind of capacity. Good growers can harvest 5 or 6 times a year indoors. But let's see, slide 5 is about the number of unique products that have been registered in Vermont. There's a product registration requirement that is how we double check that everyone's kind of testing results are in and accurate and that their product is child resistant and kind of meets the labeling and packaging guidelines and the advertising guidelines. And so through that process, we also get to kind of see just how many unique products they are and what types they are. And so this slide 5 demonstrates that the vast majority of the products out there are unique strains of flower. But then there are kind of a growing number of extracts and edibles and tinctures. Slide 6 is about the compliance work we've done. I think we've done over. Okay, now this is just about the complaints received and the investigations we've conducted. I think we've done over 1,000 site visits is what I was going to say in the last year. But as far as kind of the compliance actions, we have an anonymous complaint process. People submit complaints. Those lead to an investigation. We always try and, for unintentional violations of our rules, and this is a complex industry, and these are, operators that have never been subject to any regulation in the past. So kind of it takes a lot of work to kind of introduce people to concepts of why you need insurance or why you need pre-approval for an advertisement, some situations like that. We've taken 30 enforcement actions, and we had to issue that one health and safety warning that led to a product recall last year. The slide 7 is just kind of some internal metrics about the number of days it takes from a person hitting submit on their application to the time that they're approved. It's 88 weeks, generally speaking, from the time of submission to the time of approval for standard. And I mentioned that social equity applicants get kind of priority treatment and an expedited review. So it's 66 days for them. Advertising data, advertising is a hot button issue in the industry. We're one of a minority of states that potentially the only one that has to pre-approve advertisements before they're aired or before they're put in a newspaper. We have very strict advertising requirements. I include this data mostly because there's always this kind of push to say, well, why don't you get rid of that pre-approval process? Why doesn't the legislature get rid of it? Slowing things down. I think this is an important slide in response to that, which is we deny 40% of the submissions that we get. And if people were going to just air them, then those 40% denials would actually turn into administrative actions. And, we would have to penalize people advertising violations or some of our, they don't have to be, but they have the capability of being kind of category 1 violation, one of our most serious violations. So, I think this is an important part of the education first approach, which is where we review the advertisement. We explain to people why it's failed for any number of kind of statutory reasons, and then they can resubmit.
One question I have on this is, I think we've heard from, especially some retailers, that one of the pre-approval burdens that they're feeling when they're complaining about this process has to do with labeling that is substantially similar to label. They have a product that's been approved. They have a label that looks almost identical to a similar product that they already have approved. So a similar label's been approved, a new product's been approved, and then they just want to have the ability to do the label in the same way for the other product that's been approved. Does that make sense? But then they have to go through the pre-approval process, and that can be.
Yeah, and that's not related to advertising. This is a different workflow.
That was included in these numbers.
Sure.
Not about the labeling advertising.
No, that's the product registration piece, that's the advertising piece. But the promise of the regulated market is that what's on a label is an accurate reflection of what's in the product, and that everything is kind of been tested, been through a regulatory process. There's probably ways that we can find efficiencies, and certainly we did bring in more of our compliance team to work with the licensing team on product approvals. I think our kind of, that same metric, date of submission versus date of approval, is pretty good for product registration, but I'm sure there's ways that we can kind of dial it in even further.
Thanks.
If there's any just questions about revenue, this is all coming from the Department of Taxes. We generated $3.75 million just in the kind of fees, the application fees, license fees, product registration fees, and then the administrative penalties that we've issued. When it comes to taxes, we have kind of the first 13 months worth of data. Taxable sales, $97.03 million. That equates to $13.58 million in excise tax collected. Of course, 30% of the excise tax goes to substance misuse prevention efforts around the state. And then the sales tax is $5.82 million. And that is earmarked 100% to go to after-school programs. The last slide here just kind of gives a very dismal picture of the medical cannabis program registry. There was a high watermark right around 2017 pre-home grow. of, maybe 5,300 patients around there. I think as of this week, we're down to 2,800 patients. So that's the last slide there. Happy to take any questions about the kind of state of the market.
Representative Rohickey and then Representative Washington.
Those taxable sales of 97 million. What was the expectation?
That is significantly higher than the expectation for year one. I think when we were developing our models, we were looking to how quickly other states licensed people. In other states, it could take, 6-9 months to get licensed. And so we didn't think that we were going to have as many, for instance, retail operations or cultivators or product manufacturers in year one. So this is more akin to our year two expectations. However, it also, I think, is not, the tax department kind of shows you the month-over-month sales. With this, the last 3 months, there's been 57 retail operations. And those 57 have on average netted, I think, 9.5 million in taxable sales every month. So though, if that were to remain static, which, this is not a static market, but if that were to remain static, if you extrapolate that to a year, full year, that would fall short of what we expect this market to reach, the potential that this market will reach, which we think is probably in the realm of somewhere between 160 and 190 million.
Yeah, thank you. I do take from this, though, that the filters we have on advertising have not really hindered sales.
Well, I think that's an appropriate kind of observation.
Representative Wires Evans and then see Representative Cooper.
Thank you. I know we're going to talk about this more at a different time, but I just had a question about the advertising thing. So when you say there were 263 total submissions received and reviewed, and 58% of them were approved, and then you give the reasons why they were denied. Do you have like a back and forth process where you can try to get as many, like how many of those? So it seems like 58% were approved, but the ones that were denied, were they given an opportunity to go back and make changes and like?
Absolutely. I mean, we
Okay.
send them a letter or an email explaining kind of the very basic kind of provisions that they violated, whether it's, deceptive or misleading language or appealing to youth, or insufficient audience composition data. And there's no fee to kind of have us review an advertisement. In fact, we're proposing in this bill to just make sure that's clear. It says you may charge a fee, and we are going to just eliminate. We would prefer that be eliminated, just so it's clear to everyone who's submitting an advertisement that there will never be a fee for us to review. And so, yes, people can resubmit as many times as they want. They can kind of take the information that they receive from us, tweak their advertisement, and resubmit it.
Okay.
Representative Cooper.
More.
That's sort of the area I was looking at too. The prize award inducement, 15%, appealing to children, 5%. Can you go into that a little, particularly the appealing to children? I imagine it's pretty easy to discern between advertisement has Daffy Duck as opposed to Stormy Daniels.
It's very challenging. The law says can't be appealing to children. Well, that's obviously pretty subjective, and reasonable people disagree on what's appealing to youth. And is children, is it defined by people? Is the threshold between a child and an adult 21, which is the age limit for sales? Is it, are we talking about, young children? We certainly, the obvious, we have a matrix that's published on our website that kind of explains how we're grading an advertisement and how it's going to be. And we have some guidance about, you can't use kind of anthropomorphized characters. You can't use kind of like Disney characters, certainly. We just try and be consistent with that matrix on grading this and kind of, and this is where the back and forth comes in. It's just like this, this one has those big kind of Disney eyes. Like you got to get rid of those, like this. We just don't want to. We don't want to make some of the same mistakes that have been made in other industries, so far as kind of creating a new generation of people, consumers that that are being marketed to.
And is the prize award or inducement go so far as to say we're having a sale on this particular type of flower or?
I don't think so. I don't think that's enough here.
It sounds like there's some interest in advertising, so what I might suggest is we take a little bit of testimony specifically on advertising guidelines at some future point when we take this back up.
Yeah, that makes sense. I mean, it is a complex area and it's one of the friction points that we always have. I mean, it's very challenging and other states have, I mean, what we're seeing also is we're seeing out-of-state companies advertise in Vermont, out-of-state cannabis companies, border towns that have dispensaries are putting ads in 7 days. And so it's kind of also an uneven playing field. So,
So the net effect of that, I think I understand, is that they would not be able to advertise that product if they were trying to maintain their license in Vermont.
That's right.
In our Vermont cannabis market.
For the most part, I mean, it depends on your advertising, but yeah.
Representative Byron.
Thank you. Just a quick question on step 2. So seeing the retail, or we've seen like the licenses obviously go up over the course of the first year, but the testing lab number seems to have remained the same. Is there capacity keeping up at those 2 facilities?
They are, yes. It obviously fluctuates depending on harvest time, in November, it's probably longer waiting times. And I think, we were authorized to create a quality assurance lab. I think that will also help reduce the strain on the testing facilities because, we're using the private labs as well currently. We have compliance issues. We send our samples there and of course we get moved to the front of the line, which is helpful for us because we need to act quickly, but it's a detriment to all the other people that have products waiting in line.
Yeah, how's that going with you folks over the course of the last several months?
It's going well. I mean, we have the equipment ordered and we're starting interviewing for our lab director. We ran into an issue about where the lab is going to be located and BGS had to do a lot of kind of analysis about the existing locations and how much upfit they would need. And then of course the flooding happened and everything just got put on pause. So we're, I think, about 3 months away from having a lab. And we would have liked to have been up and running right now.
No, thank you. And I don't know how closely you folks monitor this, but my other question was, are you aware of or do you know, can you speak to fluctuations throughout the cycle of the year and the price per pound within the market itself? And I know that's such like a variable thing based on, tier, product quality. I know there's a ton of variables, but like, has it been significant or just not something to speak to?
Just like you said, a lot of what we have, again, 80% of our growers are 80% of our nearly 400 growers are tier 1 small cultivators. And so the quality fluctuates tremendously. The nice part, of course, is like, if you're not great at growing cannabis, then you don't sell it as flower, you put it into an extracting machine and it gets put into an edible. But it's remained relatively constant, I think, because our demand is exceeding the supply still, which is kind of a year 1, year 2 problem. We usually see the reverse problem in out years in other markets. So I think it's relatively stable and people are also getting very good at preserving their cannabis, either flash freezing it or kind of using certain methods to make sure that it's going to be good in 6 months, so that they can weather a price drop around harvest time.
Okay.
All right. Thank you for that presentation. So I think the next step along the way here is to ask you to walk us through back through the bill and give us some more context for some of the requests. I didn't tee this up for the committee, but obviously my name and Representative Byron's names are on as sponsors of H612, but the language that's in here these are the recommendations this year for us to start for cannabis policy, as recommended by the Cannabis Control Board. And so Chair Pepper worked with Legislative Council and to bring us these proposals. So while I want these on the table, these are not language and policy proposals that we're just kind of pulling out of the air. So I should say that pretty emphatically for the committee here.
Yes, thank you for that. I mean, this market still has some challenges ahead of it. And I think section 1, this is a pretty major one. To understand section 1, I'm going to try and put this in a way that doesn't kind of cause too much confusion. But you really have to start with marijuana, as it's called in the Controlled Substance Act, being Schedule 1 controlled substance. And then the 2018 Farm Bill, which created a legal fiction that the same plant, cannabis, is hemp, as long as it is below 0.3% THC on a dry weight basis.
That's the federal Farm Bill.
The federal Farm Bill, right? And the thinking at the time was there was a lot of desire to grow hemp for fiber, for grain, for seed, and of course for CBD, which is essentially the non-psychoactive compound that has shown some therapeutic potential. Unfortunately, in 2018, it was a simpler time. We didn't necessarily know about all of the lesser intoxicating cannabinoids that are in cannabis, or some of the manufacturing process that can be applied to THC and CBD to synthesize it into different derivatives that are intoxicating. Thinking about Delta 8, Delta 10, THCO. And so if you fast forward to 2024, a major interstate industry has developed alongside regulated cannabis industries for hemp-derived intoxicating products. They're brought to you through the mail. They're in gas stations, they're in vape shops, they're in grocery stores. There are no THC caps on their serving size. So, you think if I'm an operator, I'm thinking I just have to keep this product below 0.3% THC. Well, I just have to increase the size of the product in order and I can pump as much THC as I want in it, as long as I maintain that ratio. So like an 85-gram candy bar could potentially have 255 milligrams of THC in it, if you just maintain that ratio. And the argument is because it's 0.3%, of the entire weight of the product, I don't have any packaging restrictions. I don't have any child resistant restrictions. I don't have any advertising restrictions. I can ship it through the mail. I can ship it online.
So I want to back up for the uninitiated, maybe let Representative Hango ask her question, because I think she'll probably ask what I was going to try to tee up. Go ahead, Representative Hango.
Thank you. I just wanted to ask you to repeat that last sentence. There are about the candy bar, and then you said there are no something. You just talked too fast.
Oh, my apologies.
Yes.
Okay, so.
I couldn't process.
Yeah, I mean, essentially the hemp and the Farm Bill says all hemp derivatives is based upon a definition of less than a certain threshold of THC based on the entire weight of the product. And so people have been manipulating that to create high THC hemp derived products that are intoxicating. And because it's hemp derived, essentially they're making the argument that this is legal for interstate commerce, that none of the state regulatory requirements around child resistant packaging or labeling or warning labels or age gating, importantly, apply. And we're seeing these products in Vermont.
Yeah, I guess you didn't repeat exactly what you said, because I got all that. There was just something you said that I couldn't.
Your candy bar analogy.
Yeah.
Okay, and well, an 85-gram candy bar, which is, Snickers bar, I think is around 85 grams. Based on that, if you extrapolate the 0.3%, it could have up to 255 milligrams of THC in it. Again, our per package cap on the adult use side is 100 milligrams per package.
Oh, 100. Okay.
So that is 2.5 times as much THC as we even allow on the adult use side.
So backing up from that, I want to be clear for all of us where these products are coming from. So when you say hemp derived, you're talking about plants that are grown as hemp, not plants that are grown originally, going all the way back to the cultivator. These are hemp with low THC,
Right.
but then it's processed, purified.
Take everything out but the THC and then put it into a candy bar.
And so that's essentially a loophole that these particular.
They would argue that it's not a loophole, because the Farm Bill's language was so loose. And it wasn't, it didn't contemplate this. It really didn't. And so this is a subversion of the intent of the Farm Bill, and we've talked to our federal delegation about fixing this. Of course, the Farm Bill is reauthorized every 5 years. It didn't get reauthorized last year because of, I think, the complications with the, federal government.
Representative Hankin.
So the Farm Bill was not reauthorized, so is this still allowable under the federal Farm Bill? Okay.
Well, I should say, is it allowable? The FDA is the person that, if you're talking about kind of dietary supplements, which I think is what most people assume that hemp-derived products would fall under, the FDA has thrown up their hands on this and said, we can't control this.
But they don't regulate any supplements.
Well, they've said that the dietary, the FDCA, the Drug and Cosmetic, that regulatory framework should not apply to hemp-derived products, but they don't have sufficient staff or regulatory authority to deal with this issue. So they're actually asking, at the same time, they're asking Congress for more staff to if they want. They've sent a few kind of cease and desist letters or warning letters based upon hemp-derived products, including therapeutic effects like this Delta 8 will kind of help you sleep at night or something like that. But as far as them kind of actually pulling products off shelves or doing any sort of independent testing, they're not doing it.
One last thing for you, and then I'll stop asking questions. I could go to any store that sells healthy products. I'm thinking of a local retailer that markets themselves as a natural food store. And I could buy a granola bar that's made with hemp seeds or product. You're saying I do not know as a consumer that I may be ingesting high THC products. Is that what you're saying to me?
I am, although usually, the point of this is to market it in such a way that you know that you're going to get intoxicated, although that's not always the case. If you're not actually paying attention to the label and you're just saying this is hemp derived, must be okay, then you may find yourself in a situation where you are having an intoxicating effect.
So that's what I would argue that most consumers do. They walk into a reputable store that sells alternative health remedies. They pick up a product that contains hemp, they take it home, they ingest it. They have no idea that it has a high level of THC. So where would I find that information if I were that consumer who decided to be very deliberate about what I was ingesting and not ingesting?
I think this fix would be the thing that would enable us to step in and say that, because what we did by emergency rule, I think, Representative Higley is probably well aware of this, first through emergency rule and then through permanent rule, was to create a definition of intoxicating hemp-derived products and then have all of those have to work through the cannabis regulatory framework. But the problem is that in Title VI, the agricultural rules, there's a definition of hemp-derived product that incorporates the federal definition. So, there's a conflict there. Our administrative rule says one thing about hemp-derived products. The Title VI says a different thing. And so what Section 1 does is it squares those two up and says it incorporates our definition of intoxicating hemp-derived product that's in rule into statute, so that it's very clear that this is not a kind of dietary supplement sell at the gas station kind of product. This is a intoxicating product. It has to be labeled, it has to be tested, and it has to be sold to people over 21 at an adult use retail.
So one last question, how do we supersede federal rule, federal law?
So that's a really good question. And I think it's one that is playing out, and there's a variety of different rulings in various states right now. Because I think, well, our definition of intoxicating hemp-derived product is based upon a number of other states that have more mature markets that have gotten ahead of us on this, including, Oregon and Colorado. And there are a diversity of opinions from federal judges and state judges about whether the federal preemption applies to these rules, and it's come down on both sides. And so I did just happen to run into the Attorney General and mention to her that, her team should probably look at this. So I don't actually anticipate this being the final word on this. And I think Michelle mentioned that she wants to get Michael O'Grady in to talk about the kind of nuance of this as well.
Yeah, so we'll definitely come back to this, take some more testimony. I also want to, especially given Representative Hango's questions, I want to show the committee what some of these products that are unregulated right now look like, because I think the obvious ones are the ones that are definitely saying you will get high taking this, and it doesn't. All of the regime that we've set up with the Cannabis Control Board does not apply. And to me, that's a huge public safety issue. It goes in the face of all the work we've done to create a responsible cannabis market. So appreciate you bringing this. I think we'll just kind of put a pin in section 1 for now and come back to it. But really an important part of making sure we preserve public safety.
Yeah, I would say almost, I think to a T, every single Vermont hemp producer has followed our emergency rule, and without any problems. We're really talking about out-of-state actors that are shipping products into our state. Section 2, this again changes the definition of control for the purposes of who needs to submit for a background check. This doesn't make a substantive change. As Michelle mentioned, we are not a law enforcement agency, and therefore we're not by default entitled to receive 50 state fingerprint supported background checks from the FBI. You authorized us to do so, but we still have to apply to the FBI. And when they initially looked at our language from 2020, the original language, they said that this definition is too loose. We can't give you criminal history records that you're not entitled to or not specific to a specific person that you have an interest in. So you need to change it. And this actually was happening in many states. And we attempted to change it once without changing the substance, just getting more specific about who is the controller of a cannabis business. And they denied us again. And so it's not that we're not doing background checks. We have hired a third party kind of firm that does extensive background checks, 50 state background checks, but it comes at a price tag of about $400 per controller. And some of these businesses have, 10, 11 controllers. So it's a significant cost. Whereas a federal background check, I think is $35. So this would be, if we can kind of fine tune our definition of control, it will mean that we can, once again, maybe reapply. I mean, we will reapply with the FBI and try and get this authorization to receive these records. This specific language is akin to 2 states that just got approved, New Jersey and Connecticut. And they both kind of were denied initially and they tweaked it. So I think this one should work, but it's all kind of in the hands of the FBI.
Any questions on that? We want you to have the power to get the background checks you need. That's important.
Yeah. Right. If anyone has questions why we need background checks, I'm happy to go into that, but it is a statutory requirement. Yes. Anything else? So section 3, and I know this is a controversial section. So there are currently 4 statutory caps on THC concentration in cannabis and cannabis products. There's a 30% THC cap on flower, smokable flower. There's a 60% cap on solid concentrates. There's a 5 milligram serving size cap on edibles and a 100 milligram per package cap on edibles. So this section proposes to eliminate the first two. I think the CCB has been asked, I think in 2 subsequent years to evaluate the efficacy of these caps and submit reports about them. We've done that. I think the kind of dividing lines are pretty clear at this point. The CCB's opinion is that some people rely on solid concentrates. Either they've developed a tolerance to THC and need a larger dose, or they prefer taking one hit of something as opposed to smoking an entire joint and all the particular matter that goes with that. So those people are using the illicit market to supply that demand. And it's dangerous for everyone involved, including the producers of those. We can do a better job at educating people about appropriate dosing, negative side effects at the point of sale. We can kind of have better labeling. But that being said, like that argument is probably for another day. I think the very presence of this in an omnibus bill really kind of distracts people from the other things that are in it, because I know that this attracts a lot of attention. I see this as a placeholder for a broader conversation about the medical program. The medical program is facing significant headwinds. From the kind of patient side, we hear consistently that it's unaffordable and accessible. There's very few locations around the state, and a lot of folks want to focus on adult use. And then from the operator side, from the dispensary owner side, they're having a very tough time making the finances work. There's a kind of ever dwindling population of patients. And, they have these standalone brick and mortar dispensaries. It just seems like if we're not going to do anything about the program this year, the program itself may not exist, or at least look significantly different in a year from now.
This is just a comment, but isn't this kind of what we expected, that once the adult use market opened up, that the medical dispensaries would suffer? I mean, that just seems like that's what we predicted.
Yeah, it is predictable, I should say. It's happening in every other state, with the exception of 1 or 2. There are certain benefits and services about being a medical patient that just don't exist on the adult use side. And so you wrote into the legislative intent of the original Cannabis Legislation Act 164, it's the intent to continue to provide the same services and products to patients on the registry, even in the advent of adult use. And some of those, just to be clear, are patient confidentiality. There are a lot of people, including veterans, that, at least theoretically could be jeopardizing certain benefits that they have, federal benefits that they have, if it's known that they're using cannabis. There's specialty products, the high THC solid concentrates. We just put out a survey, kind of a patient satisfaction survey, and of the respondents, about 20% or 15% of them use solid concentrates. And there's delivery, and there's individual consultations with people that can really help someone who's, has cancer, wants to try cannabis because they aren't eating or something, or have nausea. What should I use? And I don't think the adult use system is set up perfectly to answer those types of questions. And so we were asked last year to look at ways to improve the medical program and propose some recommendations. We've done that. There's a report that's due next week that did that. We worked with a number of stakeholders. We essentially laid out 3 options for you. And one is to kind of just let the program continue this downward slide and eventually just go away. The second would be to try to improve the economic viability of the current system, primarily through lowering fees. And I mean, really, the only thing you can really do is drastically increase the number of patients that are eligible to use it to make the economies of scale work. But the third option, which I think is the preference for the cannabis board, is to begin to merge adult use and medical use. You know, you don't necessarily need to have a standard brick and mortar medical dispensary that only serves a ever dwindling number of patients. We propose creating what we're calling a medical endorsement on an adult use retail license. That if you're a retailer, and you're willing to kind of provide those benefits to a patient that comes to you, including kind of maybe having a separate entrance or having curbside delivery or some way to protect patient confidentiality, some way to protect patient information, some way to provide enhanced kind of education for the people that are interacting with patients, then you would be permitted to serve those patients tax-free. Right now, what's happening is a lot of adult use retailers they're doing some of these things and they're just absorbing the cost themselves. So we want to kind of formalize that process and make sure that patients have continued access to the services and products that they've grown accustomed to. So what's in that report hasn't been released yet. It's just a preview of it. So when this bill was being drafted, there's a number of sections in here that deal with kind of, all right, if the medical program does go away, here are the things that you would need to do to make sure that patients can at least have access to the products. And that's why this cap is in, the removal of this cap is in here. But again, I just wanted as a placeholder to talk more broadly about the way to fix the medical program.
And I think we will continue to have that conversation here as we look at this bill. So I don't know that I would like to get through the bill
Yes.
in your context today, but this is not the last time we're going to talk about this. And I know a whole number of people, including a couple folks who I've put on the agenda for this morning, have asked to testify primarily on this specifically. And I think that we'll make space for that conversation. I just didn't want people to feel like, we were going to expedite this bill quickly. We're going to have some time to talk about this, both with getting testimony and as a committee, because I think it's an important conversation to have for all the reasons Pepper just brought up.
One thing that did come out of that study committee as well, I mean, we had a deep dive into how other states add new qualifying conditions, but and so we have a recommendation around qualifying conditions. One that just seemed like it was worth just recommending right in this bill is adding ulcerative colitis to the list of conditions that would qualify a person to receive a medical card. And the thinking there really is, you have Crohn's disease, and whether you believe cannabis is an effective therapy for inflammation or Crohn's disease, it's on there. And we have a number of people that came forward and said, listen, Crohn's disease and ulcerative colitis are both inflammatory bowel diseases. I have ulcerative, not me, but people are coming forward and saying, I have ulcerative colitis. Chronic pain is a symptom of my ulcerative colitis, so I still can access the medical program through the chronic pain. But really, like, if you're going to have Crohn's, you should really have the other inflammatory bowel disease, the other major one on there as well. And so that logic held with the board, and so it was in this bill just to add that, or alternatively eliminate Crohn's and add inflammatory bowel diseases.
And I might look for House Human Services, who did some work in this area over the years, to weigh in on this, because I know there are some folks up there who have particular strong views after hearing lots of testimony over the years. So cool.
Another just recommendation that came out of that work with those working group meetings is just to add chronic pain to the list of currently chronic pain is the only qualifying condition that requires an annual renewal, added to that kind of 3-year renewal process, which would have the kind of secondary benefit of kind of reducing the administrative burdens on both our staff and the people with chronic pain that have to go see a doctor every year and have to just to get this form signed. And it has the effect of kind of reducing the amount of money that they have to pay to remain on the program. Section 7 is the technical amendment for the advertising. I think we've talked quite a bit about this. This is just removing the requirement or removing the possibility that we might one day charge a fee to review advertisements. Section 8, I think, is just a technical change to correct a misspelling and then remove Department of Public Safety just to oversee the program, the medical cannabis program. There's just kind of a lingering reference to them that has never been corrected. Section 9, as Michelle mentioned, every cannabis operator that's in a public building, which has a statutory definition, needs to have a certificate of occupancy from the Division of Fire Safety. Unless they're an agricultural building, though, they are exempt. And so really what we're seeing is a lot of people are independent operators. They have their kind of the 1,000 square feet of canopy, but at harvest time, they need to bring in what are called mobile trim teams. And they need to kind of cut down, harvest the cannabis and move it into a place to dry and cure it. And what fire safety is saying is like, well, once you bring an employee into your barn, it's now a public building. And you need to get all the sprinkler systems and all the kind of smoke detectors and technical aspects to bring it up to the commercial building codes. And that's just unattainable for many of our smaller operators. And so this is really about saying, well, if they were hemp producers, fire safety wouldn't be involved, because they're agriculture. That's an agricultural product. And so their barns wouldn't be subject to these kind of commercial building codes. But because they're cannabis producers, fire safety just needs some direction. Are we saying that these are public buildings or they're not for kind of these temporary workers? So this is just, I guess, another way of trying to make the cultivation of cannabis a little bit more like agriculture in the state. Section 10, again, this is related to in our rules. Probably don't remember, but I'll just say it. For larger operators, you have to kind of pick from a list of what we call positive impact criteria. And these are things that were in statute that we were supposed to kind of prioritize. And you have to submit plans to the board for how you're going to either pay a livable wage or have inclusive hiring practices or any number of ways that you can kind of satisfy the statutory requirement about kind of having a positive impact. And so you submit plans for this. And we added one, noting that patients have been complaining about access and, products that if you're a retailer, one positive impact criteria that could satisfy this requirement would be that you are willing to pay the tax on medical products on behalf of medical patients that show their card. That we put that into rule. LCAR approved it, and then we heard from the tax department after the fact. Oh, by the way, you're not allowed to pay taxes on behalf of another person. There's kind of like a transparency principle that's implicated. And so this section is to just fix that. That's that provision in our rule to allow adult use retailers to pay taxes on behalf of registered medical patients. And I think there's just a little kind of miscommunication at some point. I think that shall the retailer shall pay it should be a may. They can pay it if they want. And so I think that would be one request to the board to change that shall to a may. I think that's the end of the bill.
Okay. Any other questions for Chair Pepper? We'll definitely have him back as we work through this bill. I think we may not be taking testimony on this next week, and we'll look to get some written feedback and hear who wants to testify on the different portions of it. I want to talk to a couple of our fellow committee chairs who have overlapping jurisdiction, and we'll probably pick it the following week just to set time expectation. If a number of trains moving down the track.
We will, in the meantime, either today or on Monday, we'll be submitting a medical report. It goes to this committee and then the House Human Services and the Senate health and welfare committees. That might help flesh out some of the others, the kind of medical related sections.
And we can talk about this offline for planning purposes, but if it makes sense to have any of that heard jointly, so you don't have to give the same presentation to 3 committees, I'd be happy to help to try to coordinate that. Great, so I'll relieve Chair Pepper here, and I believe Dr. first. For joining us today.
Thank you.
Would you introduce yourself for the record?
Yeah, so my name is Charles McLean. I'm a primary care physician and a professor of medicine at the Larner College of Medicine. And I'm here today really representing the academic detailing program at UVM. And I'll give you just a brief background on that. The program is housed in the Office of Primary Care, which I run. Our team has been delivering evidence-based education to healthcare clinicians in Vermont since 1999. And the academic detailing model, educational model, is based on forming long-term trusted relationships with clinicians. Our academic detailing team consists of physicians and pharmacists, and our target audience is mostly primary care clinicians. Academic detailing model is used in several other states and by the Veterans Administration. So we develop a new topic each year focused on common issues encountered in primary care, particularly where there are new meds on the market or where there are new developments that prescribers may not be familiar with. So recent topics have included the new medications available for obesity management, novel medications for type 2 diabetes, and the treatment of alcohol use disorder. So many physicians are not familiar with cannabis, either THC or CBD. In 2021, with the changing legal landscape making cannabis more available to Vermonters, and data showing that Vermonters' use of cannabis products was higher than the national average, we developed an academic detailing session regarding cannabinoids that was directed at physicians and NPs and PAs primarily. We performed a thorough review of the scientific studies regarding the benefits, the risks, side effects of cannabinoids. We use the same thorough and rigorous process for grading this evidence that we apply to any other topic. So the academic detailing program was specifically named to participate in the Act 65 cannabis study group. And I was the representative who attended those group meetings. Sort of a side comment, cannabis products are available for medical or adult use market are very different from medications that go through the FDA approval process. So FDA approval requires that medications be tested in rigorous clinical trials and demonstrate that they're effective for treating whatever target condition they're applying for. And the side effects and adverse effects are acceptable. There are some CBD and synthetic THC products that are FDA approved to treat some very specific conditions, such as a type of childhood epilepsy and the nausea and vomiting associated with chemotherapy, for example. And these products have gone through the FDA approval process. So there aren't any FDA-approved products that use the whole plant cannabis, inhaled cannabis, or high-dose THC. So when we had delivered the messaging to our healthcare providers, the highlights of that are usually hour-long sessions. We're bringing them up to speed on what is THC and CBD and differences, et cetera. But the key messages really were that many of their patients are using cannabis products. We know that. So it is very important that healthcare providers be aware of potential benefits and potential harms. Second point was that cannabis use disorder is a real condition and it shares features of other substance use disorders. And as clinicians, we should all be aware of it, screen for cannabis use disorder as we screen for other substance use disorders. Another point we made is that THC consumption has a documented impairing effect on driving. And that as clinicians, we should be educating patients in our practices about those potential risks if they're THC users. So there are many clinical studies that have explored the effects of THC and CBD on a wide range of conditions, anxiety to insomnia to pain to glaucoma. However, the available studies have a lot of limitations based on factors such as the study design, potential bias, sample size, duration of the study. So the two issues I'd like to just address today regarding the proposals that came out, or the recommendations that came out of the study group. The first is that the recommendation regarding how new conditions are added to the current list of qualifying conditions that Mr. Pepper had referred to, is that I support the creation of this non-legislative entity to recommend or approve any new qualifying conditions. I believe this entity should include an expert in evidence-based medicine and evidence-based review of scientific studies. This could be a clinician, it could be a basic scientist, it could be a statistician, but somebody who's very literate in this area. This would assure that the non-legislative entity would be able to clearly interpret the findings from scientific studies and provide evidence-based recommendations about adding new conditions. I also pointed out during the study group meetings that it would be great to have an expert in cannabis research on that study group. And the only problem with that is that there are not that many available. Secondly, I'd like to address the recommendations the recommendation to develop a cannabis education curriculum for healthcare professionals, which was one of the recommendations. And I would offer that the Vermont Academic Detailing Program would be potentially available to help develop and deliver that educational activity based on our staffing and funding. Thank you.
And I want to direct the committee to some of the, I believe, some of the testimony that Dr. McLean gave, that some of the bullet points are captured in the Vermont Medical Society's testimony. And I don't know, Jill, if you wanted to join Dr. McLean and present some of that, and then we'll. Yeah.
If you want to ask them any questions.
Yeah.
I'm happy to answer.
Does anyone have any specific questions for Dr. McLean? And Representative Murphy, go ahead.
Thank you for coming.
Sure.
The testing rigors that anything would have to go through for the FDA. What I was hearing you say is testing for cannabis products does not have the same rigor.
Well, it has not yet met that standard. And part of the FDA approval process is someone has to develop a product, medication, whatever, and then apply. So, the issues I think with cannabis is that there's just so much variety in what's available. And there isn't a strong incentive for anybody to get a product FDA approved because, as we've been seeing over the last decade or more, the availability is moving toward a adult use market, and it's not worth the application fee and the process of going through that. That being said, there is increasing research being done on the potential benefits of cannabis. And one of the big impediments to that is that it's federally Schedule I and difficult. There's a hurdle to get over to get the permission to study it.
Representative Hagan.
Thank you. Would you be willing to submit your written testimony to our committee assistant so it can be on our webpage? Yes. Thank you.
Thank you very much.
Welcome.
Hi. I'm Jill Sudhoff Garrett, the Director for the Medical Society, American Academy of Pediatrics, the Pediatric Association, and Vermont Academy of Physicians. And thank you for taking our testimony. It is combined, like we combined our comments that we made to the CCB on the Act 65 medical program study and H612, because I think they dovetail in some places and then they don't in others. And we actually liked, like Dr. McLean said, we really supported the idea of having a non-legislative entity make those decisions around qualifying conditions, because it comes to the legislature all the time. You have to have, make these decisions on really not a lot of evidence. And so we, in the program study, we actually heard from what other states do, and we often have an entity at the the health departments of their state. And so this seemed to make a lot of sense. You could figure out who would be the representatives on this body, and you could have cannabis experts, you could have medical experts, psychiatric experts, and then patients and cannabis purveyors, I'm sure. So that's something that we support. And so we have on my written testimony, I put the things that we support in the bill, but then the other recommendations that we like in the report. And I will say that the study was pretty interesting because it was really broad. It was trying to look at what strains, what dosing, what cannabis to use. And so that's really what Dr. McLean was referring to, is that you need to have a way to really grade that evidence, and you need to have somebody who knows how to put a criteria to that evidence before you should add qualifying conditions, is our perspective. But really what happened in the program study, which I thought was pretty interesting, is our focus turned to, what's the future of the Vermont medical cannabis program? And I think that's something that you really have to grapple with here. How are you going to provide or maintain access to these patients for the products that they want to access, and then also how these decisions should be made, and then how to best provide patients on the medical cannabis registry with the best cannabis treatment information about that you would do with anything else, with interactions with other drugs, with the dosage, just safety provisions, and then also just the privacy considerations as well. So like James said, Vermont currently has 5 medical dispensaries. It seems like most of those are integrated licensees who also have recreational shops or adult use shops as well. And with little over a year of the adult use sales, the demand for the medical cannabis is clearly going down. In the fall of 2022, there were 4,300 patients. And then this fall, there were 3,088. And then James just said there were 2,800 patients. So that has become, really what we're talking about. And I think that's what this bill is trying to get at, and also the recommendations of the report. What we do not support is removing potency caps. It's not a surprise. We've come back to you with this issue, but part of that you might hear when the CCB comes back and talks about the report is just the medical patient survey that was done this fall. And I think James said that there was about 4,000 patients who received the survey. Of that, about 645 responded to the question of which cannabis products do they use. And of that, 15% said that they use the solid concentrates above 60% THC potency. So that's about 96 people. That's about 3% of the patients. And so we don't think that this is the fix that you need to do, especially just because the public health risk of these products. So just skipping ahead, the Substance Misuse Prevention Council is who you put as an advisory to the Department of Health and to the legislature on cannabis, alcohol, tobacco, and other substances. And they just put out in their report that they recommend, their number one recommendation is maintaining the THC potency cap. You can read that report. It's linked to my testimony. An area that we do think makes the most sense is the medical endorsement, because we think that these patients should have access to, what they want. And it does seem like with only 2,000 patients, the medical dispensary's viability is in question. We would recommend rulemaking around that. We do think that patients need to have the best health information. They need to have confidentiality if they want that. And then individual consultation makes a lot of sense. The most evidence-based medical program is going to benefit the patients, the providers, and probably the adult use retailers as well. And so I think that rulemaking would make sense. I'm not sure why we would charge tax for the medical patients when we haven't in the past. And so I thought the medical endorsement would mean a tax-free situation. But I'm sure that they could figure that out in rulemaking. But we definitely prefer the medical endorsement over removing the potency caps. It seems like that is not, it doesn't warrant that. And then I know it's not in the bill, but we also support the recommendation to improve patient and provider education. Oh, I just skipped ahead, sorry. In terms of the ulcerative colitis, adding that, just going back to our first recommendation of creating a non-legislative entity that can really review all of the evidence before we start adding any more conditions. But I believe Dr. McLean said ulcerative colitis would be covered because it is a chronic pain anyway. And then we don't support the extending the renewal to 5 years for people with chronic conditions, because they could be a lot of people that are on chronic medication. Like if they have a chronic condition, they're often on many medications. And so I think knowing how those interactions are going is important, and you should be working with your healthcare professional. And then, one thing that came up in the report is just improving access to accurate evidence-based patient education, and support that.
Thanks, Jill. Questions for Jill? I did want to delve into a little bit, and we will get the report. And so we're starting the conversation here, but we're going to get the report. But I wanted to delve into a little bit the distinction for the committee between the endorsement versus removing the potency caps. That's, currently the opening language in the bill. Could you talk a little bit about, if we do come up with a medical endorsement, would you envision that there would still be the availability for patients that were on the medical registry to get access to higher potency products? Or are you saying that have a medical endorsement so that they can get products that are available on the medical market today, but not products that have a higher potency cap? Because right now we don't have that cap in the medical use market.
I think we were saying that we would think that if patients want specific products, they should have access to it. It's actually a risk is more the lower dose THC, CBD products because the adult use is wanting to have, the higher, those are the bigger sellers are the higher doses of THC products. And so I think that some of the risks is actually, and where the evidence shows is that those lower dose products actually have a better pain relief. And so, yes, I think there could be some products that you just, they'd have to work with the medical program. But like I said, only 3% of the patients use the high potency products right now. So we're not talking about a huge demand. And so, but I just say that we shouldn't remove the potency caps for everyone, but if someone has a specific product and they're a patient, I could envision that, being important to them.
More questions for Joe? Thank you for being here as always.
Thank you.
So we have more testimony scheduled on this afternoon, probably about an hour's worth. And I think that our work, so I want to get the vote in on the South Hero charge change bill. I had that scheduled for after, but given that I have at least one committee member that is going to need to leave at 2, and I think that work will take no less than, it might only take a couple minutes, unless there are big surprises about the South Hero bill. So if everybody could be here at 1 o'clock, what I'd like to do is vote on the South Hero charter bill first, and then we'll continue our testimony on H612. I also wanted the committee to know that I forwarded you all some draft resolution language honoring Will Senning. So our elections division director has been, I'm going to use the word careful, poached, procured, by the federal, yes, he has gotten a new gig and will be leaving his service in the state of Vermont. So Senator Hardy and I would like to have both House and Senate go up. So if anybody has any objection, please let me know in the next couple hours, because legislative council, in order to do all of the stuff we want to do on the timeline that we want to. So great. Well.